Cresta Court ERTM Company Limited against Avon Freeholds Limited.
Yes, Mr. Jacob.
Yes, my lords, my lady, I appear for the appellant with Mr. Fox, and for the respondent landlord you have Mr. Bates, King's Counsel, and Ms. Gibson. This appeal raises a difficult question that this court posed and left unanswered in the case of A1 Properties and Tudor Studios. If a right to manage company fails to serve a notice inviting participation on a qualifying tenant in breach of section 78(1) of the Commonhold and Law Reform Act 2002, is the recipient landlord able to rely on that failure to object to acquisition of the right to manage, even though the tenant herself may have no objection and may even support the claim? The Court of Appeal held that the failure to serve the notice of invitation to participate on one qualifying tenant in this case rendered the claim notice a nullity, as this was the consequence imposed by section 79(2) of the Act. The upper tribunal, meanwhile, held that the failure rendered the claim notice voidable at the instance of the affected qualifying tenant, and furthermore that only that tenant could take the point. The approach of the upper tribunal mirrors the approach that this court took in A1 Properties to a failure to serve a claim notice on a landlord, that another landlord could not object to that failure to oppose acquisition. In reaching her conclusion, the upper tribunal judge therefore affirmed and upheld the first-tier tribunal's decision that the appellant is entitled to acquire the right to manage, albeit for different reasons to the first-tier tribunal, and the Court of Appeal allowed the respondent's appeal and determined that the appellant was not so entitled. As part of the background to the consideration of the upper tribunal and the Court of Appeal, they both had the benefit of this court's decision in A1 Properties, and both arrived at different answers to the question based on their consideration of this court's judgment.
Maybe ask whether benefit is the right way to describe it.
Well, it provided them with lots of useful pointers, which they used in different ways to reach different conclusions. Although the Supreme Court posed and left unanswered the crucial question, the words immediately preceding the question within paragraph 69 of the Supreme Court's judgment have taken on particular emphasis in the way that the Court of Appeal in particular has dealt with this. So perhaps if we just go to that, it's page 137 of either of the two bundles. Oh, sorry, I may have the wrong page reference there.
95 or 4.
My apologies, I'm not sure why my reference is out there. I will find it. It is page 405, I think.
Yes.
Yes. So, sorry, I know why I went to 137. Sorry, in fact, if I could take you back there, apologies. The reason I went there is because in the upper tribunal judgment, paragraph 69 of A1 Properties is quoted, and a particular sentence is highlighted in bold, which just makes it easier to see what we're dealing with. So this is actually within the upper tribunal's decision.
Yeah.
At the bottom of page 137, we have paragraph 69 quoted in full. And the point that played particular emphasis is the highlighted, emboldened sentence. Section 79(2) imposes a clear consequence of failure in good time to give participation notices. No valid claim notice can be given to anyone. So the upper tribunal's approach was to say that the whole of this paragraph, 69, is obiter. However, the Court of Appeal disagreed and considered that the first half of this paragraph, or the first 5 sentences, up to the end of this bold sentence, was ratio, and therefore bound the upper tribunal and the Court of Appeal. And on the Court of Appeal's analysis, this in itself answered the difficult question that if no valid claim notice can be given to anyone, then any claim notice given was a nullity. Now, in broad summary, the appellant's case can be summarised perhaps in 5 headline points. So the first point in our submission, on a proper construction of the statutory scheme, a claim notice served in breach of section 79.2 is not a nullity. It can engage the statutory machinery and it can enable the right to manage to be acquired. Secondly, it cannot have been Parliament's intention that a landlord could rely upon a failure to serve a participation notice on a qualifying tenant to oppose acquisition that would otherwise occur following service of a claim notice. Thirdly, we say the upper tribunal was correct to hold that a claim notice served in breach of section 79.2 is voidable at the instance of the qualifying tenant who was not served with that participation notice. Fourth, to the extent that the words in the fifth sentence of paragraph 69 of Avon Properties, which we just looked at, properly understood preclude this finding, then we invite this court to depart from that reasoning, either because it is obiter or by application of the practice statement judicial precedent 1966. And fifth and finally, if that is the wrong interpretation, then we invite you to uphold the upper tribunal's decision on an alternative or narrower ground that the qualifying tenant in this case has waived her right to receipt of a notice inviting participation. Now, the appellant's written case provides quite a detailed overview of the statutory procedure, paragraphs 7 to 50. Given there is that there, I didn't propose to, at the start, go through the whole statute in detail. What I propose to do is to go to particular points as and when they arise in the argument, if that's acceptable. The way I propose to structure the submissions is to deal with it in 6 stages. So the first stage is to deal with the overall purpose of the statutory scheme, as we say it is. Secondly, to give a short overview of key statutory provisions that we're dealing with. Those are the ones relating to service of notices, sections 78 to 80. Thirdly, to make the argument that on the proper interpretation of section 79.2, it does not have the consequence that a claim notice is a nullity if served in breach of section 78. Fourthly, to make the argument that if it's not a nullity, then section 79.2 does not enable the landlord to object to acquisition on the basis of a failure to serve a tenant. Fifthly, to deal with the question of whether the first part of paragraph 69 of Avon Properties precludes this construction, and if so, should this court depart from that. And sixthly, to deal with the issue of whether one can say that the tenant has waived her right to receive a notice. So, dealing with the first of those, the purpose of the statutory scheme. This is a useful starting point, of course, in any consideration of statutory construction to consider the purpose of the scheme. In this case, we have a statement of the general purpose of the scheme set out by this court in A1 Properties. If we go to page 391, the main bundle, paragraph 25, sets out the general purpose by reference to the consultation paper that preceded the Act. There's the quotation in 25. The main objective is to grant residential long leaseholders of flats the right to take over the management of their building collectively without having either to prove fault on the part of the landlord or to pay any compensation. The procedures should be as simple as possible to reduce the potential for challenge by an obstructive landlord. The allocation of responsibility should be clear-cut, and the body through which the leaseholders take on management responsibility should enjoy all necessary powers to properly discharge its functions. At the same time, the legitimate interest of the landlord in the property should be properly recognised and safeguarded. Now, a statute, of course, may have many purposes. In this case, we are dealing with procedural non-compliance. In my submission, the main element of this to which we should be concerned is the second sentence. The procedures should be as simple as possible to reduce the potential for challenge by an obstructive landlord. The reasons for this approach, in my submission, can be seen by looking at the problems that had been identified in existing ways in which tenants could deal with poor management. For looking at that, we can go to the consultation paper. We can turn to page 1072. So section 3 gave details of the proposals to be included in the draft bill. Chapter 1, the leaseholder's right to manage. And here it has a section on the problems that were seen in the existing regime. Paragraph 2 notes there are currently 2 ways for leaseholders of flats to remove control of the property from the landlord. The first is to exercise the right of collective enfranchisement and buy the freehold. One potential problem with this that was identified at the end of paragraph 2 is that it's not always the most appropriate vehicle for addressing management, particularly when the leaseholders cannot afford to purchase the freehold. The second, paragraph 3, was to go to the Leasehold Valuation Tribunal at that stage. Now in England it would be the First Tier Tribunal, for the appointment of a manager under the Landlord and Tenants Act 1987. However, as noted in the final sentence of paragraph 3, the process is adversarial and leaseholders may be at a disadvantage against an obstructive landlord who can afford the best professional advice and representation. Paragraph 4 dealt with other remedies in respect of unreasonable management, and it noted there the right to challenge the reasonableness of service charges. And the last sentence at the bottom of paragraph 4 on page 1072, again, it can be very difficult for leaseholders to find the time and resources to mount an effective claim against a well-resourced landlord. So that, in my submission, is part of the context, and essentially it's part of the mischief which the objective of keeping this new scheme procedurally as simple as possible is intended to address. The problem of obstructive landlords with greater resources being able to defeat otherwise rights potentially available to tenants. If we go back to the Supreme Court's decision in A1 Properties, page 411 of the bundle, paragraph 98 in the judgment returns to this topic. First, the purpose of the legislative scheme, as explained in the consultation paper, includes the objective that opportunities for obstructive landlords to thwart the transfer of the right to manage should be kept to a minimum. The procedural requirements have not been included to create traps for the unwary, nor to afford unwarranted opportunities for obstruction on the part of objecting landlords, who have not themselves been significantly affected by any particular admission to comply with them. In my submission, this is a general point being made here about procedural requirements in this scheme, and I submit it's useful to keep this in mind when considering the other arguments that your Lordship and your Ladyship will hear on this appeal. Moving on to the second part of my submissions, I'd like to just briefly run through some key statutory provisions. Perhaps I'll come back to them in more detail later, but just as a starting point, if we go to page 257.
267, did you say?
257.
257, sorry.
So here we have section 78. This is the obligation to serve the participation notice. So 78.1 is the key requirement that's been breached in this case. Before making a claim to acquire the right to manage any premises, a RTM company must give notice to each person who at the time when the notice is given, A, is the qualifying tenant of a flat contained in the premises, but B, neither is nor has agreed to become a member of the company. This provision may require service on potentially hundreds of tenants. It does depend on the facts. In this case, we have a rather small block, but the rule that you're considering in this case will apply to all cases. And we've included in the appellant's written case, paragraph 100, two examples of large block claims which have gone through the tribunal system. The first one, we don't have the decisions in the bundle because they don't really create a principle of law. But just by way of example, the first one, Metro Central Heights RTM Co., looking at the decision, it appears that participation notices are likely to have been required to be served on 178 tenants out of 422 in the block. The reason I come up with 178 is because it does give you the number of tenants who were members of the company. They would have needed to serve anybody who was not a member or had agreed to become a member. So it's not certain that it was 178, but it's perhaps a good inference that it would have been in that region. The second of the two is Chelsea Bridge Wharf RTM Co. There it was a claim in premises containing 1,200 flats. Now, it is part of the scheme that at least half of the tenants would need to be members to make the claim anyway, so one wouldn't need to serve all of those, but it does give you an indication of how many one might need to serve. The notice must have certain information. We can see at subsection 2 there as to key information it must give as to the company intending to acquire the right to manage. 2b, state the names and members of the company. 2c, invite the recipients to become members. 2d, it has to contain such other particulars, if any, as may be required to be contained in those notices by regulations made by the appropriate national authority, and we have some regulations which we may come back to later. Must also comply with the requirements, if any, about the form of notices, and again, the form has been specified in regulations. Then it has 4 to 5 rules requiring it to the notice to either be accompanied by a copy of the Articles of Association of the company or including a statement about inspection and copying to give the recipient the ability to see what they'll be signing up to. 5 requires a statement to be included which has to specify a place in England or Wales at which the Articles of Association may be inspected, and then also specify some times during which it can be inspected, and there are restrictions on what times can be offered and restrictions on what place can be offered for inspection. There's also provision for a fee over the page to be charged for a copy. And then there's an interesting provision at section 78.6 on page 258, where a notice given to a person includes a statement under subsection 4b, the notice is to be treated as not having been given to him if he is not allowed to undertake an inspection or is not provided with a copy in accordance with the statement. This does lead to a slightly unusual situation that in a case where participation notices are served on all the requisite recipients, at the date of service, the RTM company may have complied with section 78.1 by serving all the requisite parties. But subsequently, they may be deemed not to have complied if, for whatever reason, they don't provide inspection within the requirements of the statute. So between compliance of service of notices of invitation to participate and service of the claim notice, the compliance with section 78.1 may fall away. Over the page, section 79 deals with notice of the claim to be given. Section 79.1.
Sorry, did you skipped over 78 second, didn't you?
Oh, yes, I did. Sorry. Yes, there is a saving provision. Yes. A notice of invitation to participate is not invalidated by any inaccuracy in any of the particulars required by or by virtue of this section.
I mean, Parliament clearly had some idea that there might be an inadvertent failure to comply with the requirements of section 78, and they specified one saving provision but not any others.
Yes, that's right. So, yes, in relation to inaccuracies in the particulars, we know that that is saved. It doesn't cover any others.
And Parliament presumably would have had in mind that this requirement could apply to the sort of large blocks that you mentioned in paragraph 100 of your written case. I mean, yes. That's not rocket science.
No, it's not rocket science. This issue actually cropped up in A1 Properties. A similar issue cropped up that part of the argument of my own friend Mr Bates, as we were both in that case, was that if there is a savings provision, the court can infer that Parliament didn't intend any other failure to be saved because it specified what can be saved. And the way the court approached it was to say, no, one can't assume that anything else results in invalidity. It's an open question unless Parliament has specified the consequences of a particular failure. So, Parliament may tell you that some breaches can be waived. Parliament may tell you some breaches cannot be waived. And Parliament may leave it an open question in the middle as to what is the effect of this breach. In A1 Properties, the failure to serve a claim notice on another landlord was considered by the court to be an open question. It hadn't been specified by Parliament. In this case, the problem that the appellant suffered in the Court of Appeal was the Court of Appeal said, well, Section 79(2) specifies a consequence, so you can't engage in the analysis of what would you consider Parliament's intention was as to this breach.
I thought you'd conceded that in front of the upper tribunal.
Yes. Well, originally, no. So originally our argument was that is wrong.
In light of A1
yeah,
Properties.
So in light of that, at that stage we didn't consider it realistic to persuade the upper tribunal otherwise.
But you do now.
Well, persuading this court to reconsider its own conclusion is perhaps a different task to mount rather than persuading the upper tribunal to reject the analysis of the Supreme Court. But, yes, just on the issue of A1 Properties, so there are two ways of looking at it. So one is that, as the Court of Appeal says, that emboldened line that I read out earlier, the sentence, answers the question because the meaning of that is that any claim notice served is a nullity. So the difficult question is answered. It seems slightly unusual that this court would make that clear statement but still leave unanswered this question if it was that simple, that answers the question. Why would this court not say, well, there is no further question to be asked? So one way of looking at it is it answers the question. The other way of looking at it is to say, well, does it actually answer the question? Does it deal with this further consequence? The Supreme Court's decision suggests it's not a clear cut that it deals with the further consequence because it says, despite the fact that no valid claim notice can be given to anyone, the court left open the difficult question of whether there's a further consequence that a landlord can rely on the breach to oppose acquisition. So one way of analysing it is to say that it hasn't answered the question. But if the Court of Appeal is right and this court answered the question, then yes, in order to succeed, we do have to ask this court to depart from that analysis. Going back, if I may, to section...
Do you have a reference within the A1 case to dealing with the absence of other provisions, what you might call saving provisions, in a section which otherwise does have one, like 78(7?
I think I can find it, my lord.
By all means, come back to it if it's easier.
102, I'm told. Thank you, my own friends.
Paragraph. That's paragraphs, isn't it? Yeah. Thank you.
So, I could just go back to page 259, so section 79. Just going to briefly, at this stage, show the court the provision relating to claim notices. Section 79(1), a claim to require the right to manage any premises is made by giving notice of the claim, referred to in this chapter as a claim notice, and in this chapter the relevant date in relation to any claim to require the right to manage means the date on which the notice of the claim is given. Section 79(2) is then the key provision that has been held to be against my client on this. The claim notice may not be given unless each person required to be given notice of invitation to participate has been given such a notice at least 14 days before. 3, the claim notice must be given by an RTM company which complies with subsection 4 or 5, and these provisions deal with how many members the company must have. And if there are only 2 qualifying tenants, they must all be members. Otherwise, it must be qualifying tenants of not less than 1/2 of the total number of flats in the building. Subsection 6 states who the claim notice must be given to: landlords, other parties to leases other than landlord and tenant, and managers appointed under the 1987 Act, which the Supreme Court in A1 Properties termed as stakeholders as a collective term. There's a carve-out for landlords who cannot be identified or found in subsection 7. Subsection 8 provides a copy of the claim notice must be given to each person who on the relevant date is the qualifying tenant of a flat containing the premises. Distinction one can note here between the claim notice that goes to the stakeholders and the copy that goes to the tenants. The stakeholders have the ability to serve a counter notice objection to acquisition, and the tenants who receive the copy do not have that ability. And then just briefly highlight section 80 contains details about contents of a claim notice.
Again,
and
we've got that. Sorry. Is it in the regulations that it says that, there's something like 78(7)? I think it may be in the regulations that says that an inaccuracy in the claim notice doesn't invalidate it.
Yes, 80, won't it?
Well, there's 81(1) on page 263 is the similar equivalent provision.
Oh, yes. Because what's slightly curious is it's not a requirement that you state in the claim notice that you have complied with section 78.
That's true, and that's part of the argument that I'll come to, that the claim notice doesn't enable the recipient to identify whether there's been compliance with section 78 or not. As part of our argument, which I'll develop later, is that Parliament clearly didn't intend this to be of relevance to the landlord or the other stakeholder who received a claim notice. If it was supposed to be relevant to them as to whether there'd been compliance with service of participation notice under section 78, the claim notice would give them the information to identify whether there'd been compliance with that or not.
But then that would raise a question of whether that is an inaccuracy which does or doesn't invalidate the claim notice.
Well, it can't be an inaccuracy because there's no requirement to state it at all.
I know, but so it's definitely not including it in the particulars required.
Yeah, so a right to manage company can serve a claim notice that complies with every requirement of the statute and the regulations, and that claim notice will not enable the recipient to work out whether the right to manage company has complied with section 78 serving participation notices or not. They will have no idea from receipt of that claim notice whether that has happened.
And there isn't any landlord-friendly correspondent information provision of the type we see in favour of the RTM company in section 82, is that right?
There is not. That's correct. There's another part of the argument I was intending to come to later, but yes, it's notable that the tenants have a right to information in section 82, page 264, to obtain information which the right to manage company reasonably requires for ascertaining the particulars to be required by or by virtue of section 80 to be included in the claim notice. They can ask the landlord or other parties for information to enable them to complete the claim notice and serve it. The recipient of the claim notice has no equivalent right to information to ask the right to manage company, have you served the notice of right of participation on the tenants or not? If so, when did you serve them? What was the method of service, etc.? And again, that supports the conclusion that Parliament didn't consider it relevant to the recipient to know whether they'd been compliant. If it was relevant, Parliament would have given them either the information in the claim notice or the ability to obtain the information under the statute, rather than simply making a request and seeing whether the right to manage company happens to be forthcoming or whether they wish to stick to their strict rights under the statute. It is part of my submissions, I'll come back to later. That was more on the fourth aspect of my submissions, to say that if the third part is to say that a claim notice served in breach of Section 78 is not a nullity. And the fourth part is that if it's not a nullity, can the landlord rely on the breach to oppose? And in that fourth section, I was going to deal with this lack of right to information and other aspects. What I propose to do first is to just deal with the argument that Section 79(2) cannot render the claim notice a nullity. In my submission, there are 4 arguments that support this conclusion. The first is that the words used by Parliament have not clearly demonstrated an intention that a claim notice served in breach would be a nullity.
When you refer to it as a nullity, do you accept what was said in A1 Properties, I think, was it paragraph 94, that is a sort of convenient shorthand for saying we're not saying by saying that it's invalid that if everybody is happy with it and it all goes along, then 2 years later, once the RTM company has been happily managing it, someone can uncover this defect and the whole thing will have to be unravelled. You're not saying that. It's like when you say it's voidable at the suit of the qualifying tenant, I think there was a qualification to that in A1 Properties until the process has been gone through.
Yeah, so
what are you actually saying about it being voidable until what point? And when you say it's a nullity, do you accept that that's a shorthand for what they say in 94?
No, I don't accept the Court of Appeal in this case used as a shorthand. In my submission, the Court of Appeal in this case appeared to be using it in a different context. So in A1 Properties, effectively the court considered that the claim notice served on one stakeholder when it wasn't served on another and breached the statute. That was a valid claim notice in the sense that it could create acquisition if not objected to, and then one had to consider the position of what would happen if the landlord objected.
You mean the intermediate landlord?
Well, yeah, any landlord, but in that case an intermediate
other than
landlord.
The one served?
Yeah. In this case, the way the Court of Appeal have dealt with it seems to suggest that even if nobody objected, the claim notice in this case would have no legal effect. It would effectively be void ab initio. Perhaps if I could just refer to a couple of passages in the Court of Appeal judgment which, in my submission, suggest this is the way that the Court of Appeal viewed it. So if we go to page 101, paragraph 71, it's no longer disputed by the Respondent that Section 79(2) contains a statement by Parliament of the consequence of failure by the RTM company to give each participation notice required by Section 78(1) before expiry of the 14-day deadline stipulated by Section 79(2). Namely, the claim notice may not be given. On the face of it, this is a clear and unqualified prohibition such that a failure to comply with it will have the effect that the claim notice is invalid and it therefore cannot set in motion a valid claim to acquire the right to manage. Now there, in my submission, what is being said by the Court of Appeal is that it's invalid in the sense that even if nobody objects, it cannot engage the statutory machinery. So whether the stakeholders didn't respond or whether they put in a counter notice saying we admit that you have the right to manage, it cannot set in motion a valid claim, so nothing happens. The statute does not come into effect. It is a nullity. That's the sense in which the Court of Appeal were using this term.
Why isn't that just a fair reflection of the emboldened sentence from paragraph 69 of the judgment in A1?
Well, that's what I'll seek to persuade you, that can't be the effect of that, if I can go through my 4 points. So, well, the first is that one can contrast this language used in section 79(2), the claim notice may not be given unless each person required to be given a notice of invitation to participate has been given such notice at least 14 days before. That language can be contrasted with other language used in the same statute, the 2002 Act. So, the 2002 Act, as well as bringing in the right to manage, inserted a section into the 1993 Act. So the 1993 Act deals with collective enfranchisement and lease extensions. The 2002 Act inserted a new section 4B into that statute, which we can see at page 333. Now, these were provisions that were intended to bring into effect create an RTE company, so a right to enfranchise company. These have not been brought into force, and it appears unlikely they ever will be, but they were part of what was intended when the 2002 Act was brought into force. So it inserted this provision into the 93 Act, and then we can see from 4B8, talking about participation notices. So this is if a member of the RTE company wants to participate in the purchase of the freehold. Subsection 8 on page 334. For the purposes of this section, a participation notice given to the company during the period, A, beginning with the date when the company gives a notice under section 13, and B, ending immediately before a binding contract is entered into in pursuance of the notice under section 13, is of no effect unless a copy of the participation notice has been given during the period to the person who, in accordance with section 9, is the reversion in respect to the premises. So here we have some clear language used in the 2002 Act, inserting it into a previous statute, that if a notice is given in certain circumstances, it will be of no effect unless some other notice, or a copy, has been given to another party within a certain period. Perhaps closer to home, within the 2002 Act itself, dealing with right to manage, in the section on right to manage, if we go to page 250, one can see here a provision, section 74, on membership and regulations of RTM companies, and section 74(5) says a provision of the articles of an RTM company has no effect to the extent that it is inconsistent with the regulations. So again, in the 2002 Act, we see Parliament using the words have no effect in relation to something that exists in non-compliance with some other section of the statute. Section 79(2), which we're dealing with here, must be interpreted in the statutory context of the whole of the legislative scheme. We know that Parliament does expressly declare things to be of no effect, either notices or provisions in articles, if it wishes to do so. The fact that it has failed to use similar language in section 79(2) is relevant. It's not the be-all and end-all, but it's relevant to this Court's consideration of what is the actual effect of section 79(2). So that's the first point in my submission, that Parliament didn't use clear words to indicate an intention to nullify the claim notice. Secondly, the purpose behind section 79(2), in my submission, the purpose is not to specify a consequence of failure to comply with section 78. The purpose is to specify the time that must elapse after service of a participation notice before a claim notice may be given. This is one of two possible interpretations that the President of the Upper Tribunal identified in the case of Avon Ground Rates and Canary Gateway. And Mr. Justice Fancourt said that there are two options. One, it could specify a time to elapse before service of the claim notice. Secondly, it could specify the consequence of failure to give a participation notice. And thirdly, it could be both. And his conclusion ultimately was that it was both. But looking at the purpose of it, in my submission, this is demonstrated if we go back to the consultation paper that preceded the Act. Page 1076 in the bundle. Paragraph 46. The second sentence in that, to the third line down halfway across, in order to give leaseholders a proper opportunity to consider the information set out in the invitation to participate before deciding whether to support RTM, the company would be required to wait for at least 2 weeks following the service of the invitation before the claim notice could be served. In my submission, that's the purpose. The purpose is to give time to consider. It is not to specify a consequence.
That's consistent, well, it strikes me as being consistent with
what would otherwise be a duplication between 79.2 and 78.1. Because 78.1 tells us that before making a claim, the RTM company must give notice. So you've got there the requirement to give notice, and 79.2 adds to that the requirement that the notice be given at least 14 days before. If it weren't for that, it would.
Yes.
It might be thought to be a rather curious duplication.
If it weren't for that, but as your Lordship notes, it does add something.
Yeah.
That something could have been added to Section 78, it wasn't. Another thing that could have been added is...
Well, well, just to pick up that point, is it significant that it wasn't added to 78 but appears in 79?
In my submission, it doesn't affect the analysis to what its purpose is. Whether one... It's simply a matter of drafting. There are different styles of drafting. One can potentially include everything in one provision or split it into different provisions.
But if you were intending the 14 days to relate, or to give a minimum period of time for people to decide whether to participate, you would have thought you'd have put it in the paragraph in Section 78, where you create the regime for people to have a time to consider, the opportunity to inspect, etc., etc. If that was dealing with qualifying tenants, but it doesn't. It appears in the next section.
So one option would be to put it in Section 78 for the reasons your Lordship has said. Another option is to put it in Section 79 because Section 79 is dealing with the service of the claim notice. So if you're specifying a period that must be given to consider the participation notice before the claim notice is served, a perfectly reasonable alternative is to simply include it in Section 79, dealing with a claim notice. In my submission, it doesn't really assist to contrast between whether they put it in Section 78 or 79.
Well, except that it indicates that it is actually of interest to the stakeholders that the notice, the invitation to participate has been given to all the qualifying tenants that need to be served.
Well, in my submission, it doesn't demonstrate its of interest to the stakeholders just because it appears in that section. What shows us what's of interest to the stakeholders, so far as Parliament is concerned, is what's in the claim notice in my submission, rather than where this provision may appear within the statutory scheme.
But you could have very easily, just in 78.1, just at the start of 78.1, just say no less than 14 days before making a claim.
Yes, one could. But in my submission, my point still stands. They've put it in Section 79 for an alternative reason. It does relate to the claim notice, in that that's the reference point for which you give the 14 days.
But I think the argument is that because it appears in 79, it's implicit that it might have some consequence for the validity of the claim notice, whereas if it was only included in Section 78, it would just be one of the requirements for the mechanism for giving people time to consider whether they wish to participate.
Yes. Well, I'd accept that it might have some relevance so far as that goes. This court will have to consider all the arguments. That's one factor. So perhaps that's one factor against our position, but it's only, in my submission, a modest factor as to whether it appeared in one part or the other. One thing Parliament could have done, quite straightforwardly, is to say that a claim notice served in breach of this provision is of no effect, using the words that I've already shown in the court from other sections. So that would be a very simple way of drawing a line under this argument. The third part of the argument is in my submission, and this is important, I say, that if it is a nullity, that would render this statutory scheme unworkable. If the effect is that a claim notice served in breach of participation notices doesn't engage the machinery at all, that nothing happens and no rights are transferred, it won't work. And it's important. So it's a superficially attractive answer in this case because the landlord noted the problem and objected. But it's important to consider what would happen if nobody notes the issue, nobody objects, and the scheme goes through. And the reason that's important is because of the nature of this statutory scheme. This is a scheme that provides for acquisition of the right to manage without any judicial consideration or decision in certain circumstances. And that's the deemed acquisition provisions in section 90, 2 to 3, page 275. So section 92, where there is no dispute about entitlement, the acquisition date is the date specified in the claim notice under section 87. And section 93, for the purpose of this chapter, there is no dispute about entitlement if A, no counter notice is given under section 84, or B, the counter notice given under that section, or where more than one is given, each of them contains a statement such as is mentioned in section 2A of that section. That statement is a statement admitting the claim. So one can have acquisition if no counter notice, or if a counter notice, if all the counter notice served admit the right. Going further than that, the Supreme Court in A1 Properties held that RTM can be acquired even when the qualifying conditions are not met. That's in, if we go to page 407 of the bundle, paragraphs 79 to 80. So here, Lord Briggs and Lord Sales analyse a number of cases, A, B and C, to test how the scheme works. So section 79, if we look at the final sentence, take a case A, where there is a real substantive objection to the scheme, such as an RTM company not being properly constituted under subsection 79, 4 or 5. So by way of reminder, these are the provisions that say the minimum number of tenants the right to manage company has to be able to make its claim, either at least half the flats or 2 if there are 2 tenants. So case A, they don't have that. There's a real substantive objection. Under case A, going on to paragraph 80, under case A, there are 2 landlords, but only one entitled to be given a claim notice because the other is invisible within the meaning of section 79.7 dispensation. The first landlord is given a claim notice and does not serve a counter notice because it is consent with the scheme or has been bought off by the RTM company. The second, invisible landlord, is not given a claim notice and therefore cannot give a counter notice, even though, when it later finds out about the scheme, it wishes to make a perfectly legitimate objection to its validity. Without entitlement to receive a claim notice, it is plainly not entitled to give a counter notice, see section 84.1, and therefore, by virtue of section 93, there is deemed to be no dispute about entitlement and the scheme takes effect on the date specified in the claim notice. So the upshot of the Supreme Court's analysis is that even if you don't satisfy the qualifying criteria, if there's no objection by the recipient of the claim notice, the scheme can actually take effect. An acquisition has significant consequences. So perhaps I won't, just due to timing, I won't take the court to all these, but for reference, page 281 of the bundle, section 94.1, contains a duty to pay over uncommitted service charge. So upon acquisition, if a landlord or manager is holding some uncommitted service charge funds, they must pay them over to the right to manage company. So they're uncommitted if they don't already, if they haven't been, their costs haven't been incurred to which they will be allocated. So it might be reserve funds or sinking funds. Potentially very large sums of money will be paid over by the existing manager to the right to manage company. Residential service charges are often held under a statutory trust under section 42 of the Landlord Tenant Act 1987. Now, if the claim notice is a nullity, nobody spotted this, but it is a nullity because there was one qualifying tenant missed out of serving a participation notice. And if the statutory machinery is not engaged, but nobody spots this, we might have a situation where the manager pays across monies held under trust for tenants to a company that has no entitlement to them because they don't realise that this scheme hasn't taken effect.
The same would be true if the notice was given to every qualifying tenant, but one of them only got 13 days' notice.
Yes, a similar sort of situation. If that would render the claim notice a nullity, then again it would have a situation where potentially large sums of money being paid over in breach of trust because nobody realises that the statutory machine has not been engaged.
And that qualifying tenant couldn't serve a counter notice anyway. So it couldn't intervene in the statutory process that would otherwise lead to the scheme going ahead.
Yes.
Otherwise, perhaps than by way of judicial review.
Yes, so that's perhaps the alternative route for a qualifying tenant to vindicate any right they have. But yes, you're right, Your Lordship, they cannot serve a counter notice, only the landlord or other stakeholder can.
Yes.
And does the deeming provision in 93 not help then?
So in 93, yes, so there's no dispute about entitlement. Those two scenarios, no counter notice is given by a person who's entitled to give a counter notice, or anyone that's given admits the right. And we have deemed acquisition. The tenants are left out of that process.
Well, you say they're left out, but why wouldn't that, if that scenario, in the scenario you're thinking of, I think where everybody's happy, but there is actually this defect, then the defect being that one of the qualifying tenants was not served or was served too soon or not, whatever, then wouldn't 90 subsection 3 apply? So there's a deemed right to manage acquired. I don't see why it solves the case A problem, but not your posited problem. Isn't that what was being said in A1 properties at paragraph 94? Once it's done, it's done. Either through the tribunal determining it or a deemed acquisition.
Yes, well, if this court takes that view, then I am content with that. So in A1 properties, because the claim notice wasn't a nullity as such when it hadn't been served on a relevant landlord, there could be deemed acquisition as held by the Supreme Court, even if the qualifying criteria weren't satisfied. On my reading of the Court of Appeal's judgment here, it's going further and saying, well, if you don't serve a participation notice, it's a different scenario because the claim notice is a nullity and it doesn't engage the statutory machinery at all.
Yeah, so that's because you assume that despite the fact that the Court of Appeal clearly knew very thoroughly what was said in A1 properties, that they're using the term in a different sense from how the Supreme Court was using it in that case.
Yes, I do, and the reason I do is because their approach was to say the A1 properties consideration of interpreting Parliament's intention applies when the statute doesn't tell you the consequence of non-compliance. And they drew a distinction to say, well, in this case, section 79.2 tells you the consequence, so the A1 properties analysis doesn't apply. That's what the Court of Appeal was saying. So that's where I understand them to be saying, well, section 79.2, the consequence is it's a nullity, it doesn't engage the machinery, so the whole analysis of A1 properties is not available to you. And as I understand, that's part of my own friend's argument, that you can't consider the A1 properties analysis of what's Parliament's intention. You know what it is, it says very clearly, and that's how I understand the Court of Appeal to reach this conclusion that it's simply a nullity, it doesn't engage the machinery at all, so effectively it's a non-starter. But if this Court is with me that that's either the Court of Appeal wrong or perhaps I've misunderstood and actually that's not what they're saying, then I'd be content to work with that it can engage the machinery. And on my submission, it must be the case that the right to manage can be acquired by a claim notice, even if it's served in breach of section 79.2. Firstly, on deemed acquisition, but then I'll also move on later to say, well, actually, even if a landlord objects, why would Parliament intend the landlord should be able to object to it to stop the claim that would otherwise proceed?
Just wondering, did the Court of Appeal engage with the point that my Lord Reid raised, namely, what was the consequence if the participation notice was only served 13 days before the claim notice?
I do recall I was asked a question about that, but I can't remember the exact nature of the question or what I said as an answer, but it was only briefly touched upon in all submissions that didn't feature in the judgment.
I'm looking at that question again, perhaps for the first time, but I suppose one approach is this, that if what went wrong is that all the qualifying tenants were given their participation notices, but the claim notice was served only 13 days after the last qualifying tenant got his or participation notice, it could, I suppose, be said that section 79.2 doesn't actually specify the consequence of that, i.e. jumping the gun. But it said on the contrary, it does specify the consequence if you serve 364 only of 365 qualifying tenants.
Well, I'm not sure that's workable.
Well, no, I'm
They say so because the operative words, the claim notice may not be given unless apply to both situations.
Indeed, I'm not suggesting otherwise. I'm just saying that it seems to produce a curiously bifurcated approach to a single piece of determinative language.
But
The other point that might be made is that one doesn't see either the word nullity or even the word valid in subsection 2. One's just told the claim notice may not be given. Now we have to try to work out what the consequences are if a claim notice is given.
yeah, well, I would, my clients and I would be content if that was the approach taken, that it doesn't specify the consequence. One needs to ascertain what that is. And there's various pointers, which I'll go through, as to why, in my submission, the effect can't be to enable a landlord to object. Just briefly on the point that it would be unworkable if it's a nullity, so I'll just quickly run through this, but the scheme also, in sections 96 and 97, just by way of reference, they're on pages 284 to 285 in the bundle. That deals with the transfer of management functions. It provides that the current managing parties will cease to perform their contractual obligations, and the right to manage company will begin performing those obligations, so far as they relate to management. The tenants, therefore, will start paying their service charges to the right to manage company, and it will start providing the services. Now, if the claim notice served in breach of section 79.2 was a nullity and didn't engage the machinery, then one can envisage a situation where parties will be breaching their contractual obligations because a company with no right to manage will be actually trying to do the management. Tenants will be paying their service charges to the wrong party.
But all these disaster scenarios all sort of rather get away from the point, which is whether the landlord is somebody who can complain by giving a counter notice to say you didn't serve all the people who were qualifying tenants with a participation notice. That's the question.
Well,
I'm not sure how you can jump from the answer to that being yes to then, oh, well, the whole regime falls to the ground and all years of some other company having managed the property will have to be unravelled and the money will have to be paid back. I mean, that's not what we're talking about. What we're talking about is whether the landlord can object to the claim notice on the basis that there's been non-compliance with section 78. That's
true, my lady. The way I've tried to structure it is to start with, firstly, the proposition that a claim notice served in breach is not a nullity. Then the next part of the argument is that if it's not a nullity, can the landlord object, which is the point that my lady wants me to focus on. At the moment, I was just running through why I say it cannot be a nullity, because if it was a nullity and didn't engage the machinery, it just wouldn't work, because it would create this whole-scale collapse of contractual rights and obligations. It also would likely put the existing manager in breach of its obligations to third-party contractors, left, right and centre, because the right to manage company has no obligation to accept existing contracts with the cleaners and the gardeners or whoever. But if, so I'll move on. So assuming, for present purposes, that my submission is correct, it doesn't result in the claim notice being a nullity. The statutory regime can be engaged to enable the right to manage to be acquired. So then, yes, we've come to the key question. Can a landlord object to, sorry, bear with me. Can a landlord oppose acquisition?
Just before you get to the landlord's point, can I just ask, Obviously, the notice is given to qualifying tenants who are not members of the RTM company.
Yes.
What is it about the RTM company that might cause somebody who isn't a member of it to either refuse to become a member of it, I not want to take it up and take up membership, or to have something to say about? Can they say, well, actually, I don't want this right to manage company to acquire the right to manage?
Well, so
what's the purpose of giving notice to the? It seems to be a sort of one-way street. The assumption is that every qualifying tenant would want to become a member, or at least give them the opportunity. But can they say, actually, there's something about this company?
Well, yeah. I don't think it's assumed that they will all want to become members. It's to give them the opportunity to participate. So it's to just give them the availability of that. As regards whether they would take it or not, so one reason why they might not is because as the law stood until relatively recent changes that come after this, members of the company were liable for the costs of recipients of claim notices for dealing with the claim notice. And if it was disputed and it went to a tribunal and the right to manage company lost, then not only the right to manage company could be required to pay the landlord or other recipients' costs, but the members would be jointly and severally liable with the right to manage company to pay them. So that's one reason not to join. A reason to join would be to have a voice at the table, so in terms of being able to speak at meetings of members of the company. That could be to support the claim, or it could be to try and persuade others not to go forward with it.
I mean, my recollection is that the constitution of an RTM company is, in broad terms, prescribed.
Yes, so there are set in regulations, articles of association. Anything that conflicts with those is of no effect. I think a provision that I referred to earlier. There is potentially some scope to add extra provisions as long as they don't conflict, but usually they simply have the standard model articles and they set out the rights and obligations of directors and members.
Yeah, it's just I'm simply trying to follow through because it appears that the purpose of giving the notice inviting participation is to give an opportunity for the qualifying tenants who aren't members the opportunity to consider it and to give them the opportunity to look at the Articles of Association, to inspect the Articles of Association, which suggests that there might be something there that is relevant to the decision that they're supposed to be making. And I'm just trying to... I don't think we've got the articles. I don't see there's any exploration of that.
No, we can provide them if necessary, but they set out things such as voting rights, that they'll get an idea of what kind of voting right they might have. Tenants have weighted votes over landlords can join the company if the right to manage is acquired. Afterwards they can join. Prior to acquisition it's only the tenants.
But the tenants don't lose their right just because the scheme goes ahead. They can join at any time, can't they?
They can, yes. They always have the right to join at any stage.
And that's for as long as the scheme lasts?
Yes. And for as, I suppose, yes, as long as the right to manage company remains a right to manage company, they have a right to join as long as they remain a qualifying tenant. They need to satisfy the conditions of being a qualifying tenant.
They can't, any qualifying tenant who sees something wrong about the RTM company or is perfectly satisfied with the existing regime, can they object?
Well, they could. They could.
I suppose they could lobby to make sure that there were a number of qualifying tenants who objected, and therefore there wasn't the quota necessary.
They could try to do that. To make a claim, there'll always be at least half of the qualifying tenants of at least half the flats, except for the example of 2 flats where all of them have to be. But so the people who want the claim to proceed will always be the majority. Others can join, they can try and lobby, they can try and persuade, but ultimately, if the majority want to proceed, they will be outvoted.
It's a slightly curious aspect of all this that when you look at, 78, as we know, is all about the information that has to be given to the qualifying tenants. And subsection 7 tells us that the notice that's given to them is not invalidated by any inaccuracy in any of the particulars required by the section. So they can be told a load of nonsense, but provided they get something that is, can be described as a notice of invitation to participate, that satisfies the requirements of that section. Then when one comes to the claim given, the notice of claim given to the landlord, Section 80 tells us all the things that have to be in that. The names of the qualifying tenants who belong to the RTM company, where they live, and so forth, the name and registered office of the RTM company, and all the rest of it. And then Section 81(1) tells us that the claim notice is not invalidated by any inaccuracy in any of the particulars required by Section 80. So the notice of participation can be a load of nonsense, the claim notice can be a load of nonsense, and none of that will invalidate the process. But if the participation notice isn't given to everybody 14 days before the claim notice, that's absolutely fatal.
Well, on one interpretation, yes, but on the correct interpretation, no.
What on earth is the rationale of that prioritising of the timing of the service of a claim notice relative to the notice of invitation to participate,
well,
as compared with the substance of what's actually in any of these notices?
Well, in my submission, there is no reason why Section 79(2) should be interpreted as having such a severe effect. The way that this has been interpreted over time, you will have seen from the appellant's written case that the first-tier tribunal, the upper tribunal and the Lands Chamber before it have taken different views on this over time, that the effect of non-compliance with serving participation notices has changed. Originally it was look at the prejudice, then it became no, there's a bright rule, then with Judge Cooks' decision here it became, well, is the qualifying tenants voidable? The way in which, well, my little friend is in quite a lot of the cases, I think he's been quite successful on this. I think the way in which the argument started to be won on behalf of the recipients of the claim notice is the argument that this specifies a consequence of failure to comply with Section 78. And so that's the argument. Once you say it's a consequence, then it resolves the problem for the landlord. They can rely on this no matter what, because this court doesn't get to decide what Parliament intended. This court is told what Parliament intended. But that really does beg the question, well, what exactly is if it is a consequence, what is the consequence exactly that it's specifying? But there is a prior question as to, is it actually a consequence? And as I said earlier, there's another alternative, that its purpose is to specify the time limit. It's not there to specify a consequence. And ultimately, arriving at the conclusion of the Court of Appeal, it does, for various reasons, seem to be a very unusual outcome, looking at the way in which the whole of the legislative scheme works, how the right to manage scheme works, that this is picked out as the one thing that landlords can rely on to everything's off the table. You didn't serve one tenant, that's it. And for various reasons, I will submit that can't be the correct interpretation. So just looking at whether a landlord is entitled to object on this basis, probably have 4 broad points as to why, properly interpreted, that can't be the outcome.
But isn't what we're arguing about whether under 84(2)(b the counter notice can allege that by reason of a specified provision of this chapter, the RTM company was not on that date, or was on that date not so entitled, that date being the relevant date. Right, so I would have thought that what 80 subsection, or 81 subsection 1 and what is it, 79(7) are saying is that you cannot say in your counter notice, you, RTM company, were not on that date so entitled because there was an inaccuracy in the particulars that you included in the claim notice. Is that right? Is that what's generally thought? That the function of, or the effect of 79.7 and 80, I keep forgetting what it is.
81.1.
81.1 is that those do not form the basis of a counter notice served under 84.2b. Is that right?
So if there was an inaccuracy in the particulars in the participation notice, section 78.7, I think it is, tells us that does not invalidate the notice.
Right, and that means, or does that mean that a counter notice cannot claim that that is the reason why the RTM company was not, on the relevant date, entitled to acquire the right to manage?
Yes, that would be one example where a counter notice could not say that, because they can't say it's invalid because there's a specific saving provision.
Yeah. So the question is, can they, however, because there's no saving provision for 79.2, can they say the RTM company was not so entitled because they failed to comply with the obligation to serve them? That's the question.
Yes. In my submission, the answer is merely because there's not a saving provision, it doesn't mean...
All right.
That
but if they don't, if they serve a counter notice admitting, then fine. 90 subsection 3 says all goes through. They can't then say, oh, well, I wish I'd served a counter notice under 84.2b, but I didn't because I didn't know there was that problem. It's done and dusted.
Yes.
Right.
Yes, we would accept that interpretation, yes.
It rather depends on what provisions disentitle the RTM.
Yeah, exactly.
I mean, it rephrases the argument, doesn't it? So you have to ask whether the specified provision relied upon by the person serving the counter notice is one which goes to entitlement.
Right. Exactly. That's the question.
Yes, I mean, for example, the premises might not be the right kind of premises at all, or the RTM company might not be the right kind of company. There are all sorts of other provisions we haven't looked at. That,
Is this one of them?
Yes, so there is a distinction, I say, we can draw between qualifying criteria and procedural requirements. So the qualifying criteria, such as do the premises fit within the premises to which the right to manage applies, if a landlord takes that objection, then of course that is an objection they can take and it will succeed if they're right. Other qualifying criteria, there's a restriction on the amount of internal space in the premises which can be commercial. It used to be 25%, now it's 50%. So if the landlord says there's 51% commercial as their objection, then fine, yes, that's an objection based on qualifying criteria. The right to manage company can't deal with that. There's a distinction in my submission between those and procedural requirements, such as failures to serve notices. And this is, for instance, exemplified by A1 Properties, again, if we go back to that. So A1 Properties was not a decision dealing with the qualifying criteria as to whether you qualify for the right to manage. It's all about the procedural route by which you claim it. So in that case, there was a clear and accepted breach of the procedural requirement under section 79.6 to serve all landlords with a claim notice. And if I could just take you to page 410, paragraphs 91 to 92. So, just to recap, the right to manage company has to serve all landlords with the claim notice. It serves one, it misses out an intermediate landlord. It's an admitted breach of the legislation. It's admittedly failed to comply with the procedure. The landlord who was served takes the point and says, well, you didn't serve a notice on the other landlord. That means you can't acquire the right to manage. Perhaps if I could just invite the court to read paragraphs 91 to 92.
really the sentence in the middle of paragraph 92 is the crucial one, I think. Adopting a purposive approach.
Yes. So it doesn't give other persons not so affected by the procedural omission a right to object, because there's no reason to suppose Parliament would intend that they should be able to thwart the right to manage by a windfall. So if we look at section 80...
But that's applying the synergy test, isn't it?
Yes.
Right. So then is there a question as to whether you can actually distinguish so clearly between the two issues, namely, is synergy engaged in this, and then what would the result be? Because if you think, well, applying the synergy test, I would clearly come to the view that it's not intended to be something that's can be the subject of a counter notice for those reasons under 84.2b. Does that tell me anything about whether the provision itself precludes the application of synergy because it determines itself, or it says itself, what the consequences are?
Yes. So that's effectively my friend's argument. It says the consequence, so therefore synergy's out the window, so we don't need to worry about this. Which is why I say that's not the proper interpretation. Its purpose is something other than specifying the consequence, and this court should hold that it's not giving the consequence that this can be relied upon by a landlord. For various reasons, in my submission, that would make no sense. So the first point is, just as I've exemplified here, we have, applying the synergy approach, procedural omission is treated differently by the Supreme Court to a qualifying condition. I don't think anybody would argue that if this court had to apply the synergy approach to a qualifying condition as to whether the premises actually are a self-contained building, we all know the answer would be it's a bright line rule, it has to be a self-contained building. We're not mucking around here. But when it comes to procedural requirements, we have a more nuanced approach, and it's, yes, why should...
But, sorry, what would happen if it was not actually, it didn't actually meet the qualifying criteria, but the landlord didn't object? Would 93 be sufficient to deem it to be acquired?
Yeah.
On A1 properties, that's what A1 properties says, that then it would, right to manage would be acquired, even though the qualifying conditions weren't satisfied.
Even though it was not the right kind of premises?
Because
yes, that's
the claim notice presumably has to tell the landlord all about the percentage of commercial property, does it?
It doesn't have to tell the landlord that, but the landlord has ways of ascertaining that.
Yeah.
The landlord has a right of access to any part of the premises to enable it to work out whether the claim notice is valid. So that's something that the landlord can do if it needs to know, if it doesn't already know what the floor plans are of the place.
Mr. Jacob, we've up to now, I think, been looking at all of this along the lines of, well, are the synergy principles engaged or not? If you just look at it as a consequences of section 79.2 issue. But if you look at it through the spectacle of section 84.2b and ask, does the specified provision, I think specified just means pleaded in the counter notice, does the provision of the chapter upon which the objector is relying go to entitlement? I wonder if that really raises a strictly synergy question at all. It's just a question of construction of section 84.2b.
That's, yes, I'd agree with that, my lord.
Yeah.
Yes, what there is a question as to, on the proper interpretation of section 84.2b, 84.2, what can a landlord object to? And yes, my submission is that it's restricted to eligibility criteria, not procedural breaches.
Well, I'm not sure that. Well, I'm not sure it's as simple as that. But it may.
That's an extreme example. But
but you have got to look at the provision that they're relying upon and ask, does that go to entitlement?
yeah,
I mean, it might be procedural in the sense that if it's a provision that required them to be notified and they didn't get a notice or something. I mean, I'm just coming back to 92 of A1 properties. It's not necessarily a simple procedural substantive divide, but it is still a divide.
yes.
if I may say so, I mean, not having been involved in A1 properties, for me, an attraction of that approach is that it avoids having to introduce the language of void and voidable, which doesn't appear anywhere in the statute, and and perhaps not terribly well suited to this kind of context.
Yes, well...
For partly for the reasons you explained earlier, what were the consequences of nullity.
Yes. It may be a neater solution if the court is with me on this to say that, yes, on the interpretation of section 84.2, this is not a point the landlord can take. There are various reasons why that would be a legitimate construction in my submission.
Although it does then get back to the point that my Lord Snowden was making, which is if it's not a point on which the landlord can rely to serve a counter notice under 84.2b, what's it doing in section 79?
Well, I've already made my submissions such as they are on that. One way of interpreting, say, it's a pointer towards a good approach. But in my submission, it's too fine a point to really place so much weight on whether it appears in one section or another, where it does have relevance to both aspects.
Yeah.
It has relevance to a participation notice, it has relevance to a claim notice. So whether one puts it in one or the other, in my submission, is just a drafting preference. This court cannot put too much weight on that location of the provision within the statutory scheme.
Does section 84 really allow you just with one bound to be free? Because it does start with the words, a person who is given a claim notice. That's section 84.1. Doesn't it rather beg the question, what is a claim notice, to which do you not have to go back to section 79.2? Or 79 anyway. I mean, I understand why one might want to find a new pair of spectacles in paragraph 84, but I'm just wondering whether actually the opening words really allow for that.
Well, in my submission, what is a claim notice is a notice which complies with the requirements as to its form and contents in section 79. Something that if a recipient receives it, they can view this document, compare it to the statute, and from the document they receive, they can ascertain whether it's a claim notice or not.
Could it not just be said, well, what claim notice means in section 84.1 is a claim notice that you are entitled to serve because you complied with the requirements indicated in section 79.2. And if you don't, then it's not something that gets you into section 84.
Well, that perhaps, in my understanding, that would go back to the question of whether it's a nullity, whether it's actually a claim notice.
I mean,
if it's not a nullity, then it is a claim notice, and then it's just a question of what's the consequence of...
Well, I was really just putting to you, I think, there's the arguments have been raised as to whether section 84 allows you to avoid sort of fine arguments about validity or otherwise of a claim notice, and I was just questioning whether that's the case given the opening words of 84.
Well, right, my submission, a claim notice, right, I've already made the point, but our case is that a claim notice is one which satisfies the requirements of form and contents set out in section 79, 80, and the regulations as to showing you what has to be in this document that you serve. Then that is a claim notice if it is served in compliance with that. Or it doesn't cease to be a claim notice. This is our case. It doesn't cease to be a claim notice because there has been some breach of section 79.2.
Well, here's the other, as it were, arguing against myself again. What actually section 84.1 says is a person is given a claim notice by an RTM company under section 79.6. Section 79.6 is specifying the service on the landlords.
Yes.
It doesn't mention, it doesn't say given a claim notice in compliance with any other section. So it rather tends to suggest it's only interested in the landlord, the service on the landlords. It's not really the consequences dealt with by 84, and the whole panoply of counter notice and everything else that follows from it is really not interested in anything other than section 79.6.
Yeah, if I may just add to that, one thing we do know is it doesn't need to comply with the provisions concerned with the contents of claim notices, because it's not invalidated by a failure to do so. All it has to be is a claim notice as defined, which is in 79.1, defined as a claim to acquire the right to manage any premises.
Well, perhaps when we're considering a claim notice, perhaps I could just move to another point, which is we say it's important to recognise that the scheme does not give the recipient of a claim notice the ability to ascertain compliance or non-compliance with Section 78, the service of participation notices. So Section 80 tells us what the claim notice must contain, and it's got some important aspects of this, such as specifying the premises, Section 82, sorry, I'm on page 261. Section 82, it must specify the premises and contain a statement of the grounds on which it's claimed that the premises, they are premises to which this chapter applies. And then 3, it must state the full names of each person who is both the qualifying tenant of a flat containing the premises and a member of the RTM company, and the address of his flat. So all of the members have to be specified. Then it has to contain more details in relation to the members. 5, it has to state the name and registered office of the company. 6, it has to state the date for giving of a counter notice. 7, it must specify the acquisition date. Then it has to contain 8 and 9, where it has to contain particulars in the regulations and also comply with the form of the regulations. Nothing in this section or the regulations, the form that's used, nothing requires the right to manage company to state on whom it has served notices of right of participation. It doesn't have to say when it served the notices. It doesn't have to give any evidence of service of those notices. So a recipient of a claim notice can see what premises are being claimed. They can assess whether they comply with the statutory requirement they're a self-contained building or part. They can see the names of the members, other details, they know the acquisition date, etc. They can check all this. What they have no idea about is who was served with a notice of invited participation, when were they served, how were they served. The reason it's not provided in my submission is that the purpose of the claim notice is not to enable the recipients to identify whether procedural requirements are being complied with. The purpose is to enable them to identify whether the qualifying conditions have been complied with. And similarly, it doesn't have to tell them who else has been served with a claim notice. So going back to the A1 properties, one landlord gets the claim notice, another doesn't. The landlord who gets it won't know from the claim notice who else has been served and when. They may be able to find it out if they were in that case. They may not.
So you're saying, well, we can infer from the fact that they don't get that information that this is not...
Parliament did not consider it a relevant piece of information for them to be given.
And
because
therefore
they cannot object to acquisition based on the failure to serve.
It's not one of the... It's not a provision by reason of which they can complain that the RTM company was not on that date entitled. I mean, the flaw in that is that all the things that we've already ascertained, that all the things that are set out in 80, because of 81.1, are also not things that they can rely on to serve a counter notice, because we're told they don't matter.
Well, an invalidity in the particulars can be excused. Some of the authorities draw a distinction between invalidities and omissions. So simply failing to put something in will be capable of being relied on, whereas if it's put in but there's an inaccuracy, there's a distinction to be drawn. And these are the arguments that are had over these saving provisions. How far does the saving provision go? It's not a complete get-out-of-jail-free card on the current state of the authorities.
What do you say is the consequence if there has been a lack of service of a participation notice on a qualifying tenant?
Well,
what rights does the qualifying tenant have in those circumstances?
Well, we support the upper tribunal's decision to say that the tenant has a right to object, and it would be voidable in the tenant's instance.
What exactly is voidable?
The acquisition of the right to manage that would otherwise essentially take place. I think she has adopted the analysis used by the Supreme Court in A1 Properties as to what happens if you don't serve another landlord. So adapting that to this scenario, that seemed to the upper tribunal judge to be the appropriate analysis.
So what a tenant who was not a member of the RTM company at the time could object? Sorry if I misunderstood this exchange.
That's the analysis that Judge Cook placed on it, to say that only the person who has had their procedural right breached, the relevant tenant, could object. And the only way that they could object is to go to the High Court and seek judicial review or declaration that the right to manage had not been acquired. She did leave an open question as to what exactly would happen in those circumstances. Yes. She didn't say clear-cut as to what would be the outcome of such a...
The trouble is that the alternative remedy for the qualifying tenant who wasn't given a notice of intention to participate is just to join the RTM company, isn't it?
Yes.
I mean, it's just difficult to conceive of any situation in which a non-served qualifying tenant who learns that they should have been and haven't been served, i.e. that they were entitled to be served, would suffer any sensible prejudice justifying, as a matter of parliamentary intention, striking down the whole scheme. Bearing in mind the very limited advantage of early membership that the NIP process actually achieves.
Perhaps that is a better analysis. For my client's part, it doesn't actually matter, I suppose, whether the tenant has that right or not.
But we'd have to try and make sense of this complicated scheme as well.
Yes.
I mean, this goes back to the questions I was asking earlier. I mean, Parliament plainly envisaged that somebody who wasn't already a member might decline to become a member because they have rights of inspection of the articles and the Constitution and the like. And I was trying to understand why it wouldn't just be an obvious thing to do, which is to jump on board when you get to know that the right to manage company is about to serve a claim form. Why wouldn't you want at then or at a later stage?
Well, actually, one would be the potential cost liability if something goes wrong and the landlord objects.
So
if the right to manage company, if the right to manage company has enough members anyway to go forward, and they invite you to participate as another tenant, and you're happy with it, you can let them carry on. You don't need to join. There's not much difference if they're going anyway and they've got the numbers. If you do join, and then you have an obstructive landlord who comes up with a good argument as to some problem with showing the premises are self-contained, they prove the premises are not compliant, then you've signed up to the potential cost liability with all the other members. If you just stayed on the sidelines and watched it play out, you could get the right to manage potentially without incurring any personal liability.
Could there just be a genuine view that the current landlord who's managing is actually going to be better than all my neighbours who couldn't organise their way out of a paper bag? And the last thing I want to see is my neighbours becoming entitled to manage my block.
They can't prevent it.
In theory, that's possible. In practice, it's probably unlikely because people engage in these sorts of rights usually because of poor management on the part of the landlord. Also, when right to manage companies acquire the right, I suppose it might be a matter of experience. We don't have evidence, but it's unlikely the tenants will actually do it themselves. In most cases, they'll employ some professional agent to do it who's just better and or cheaper than whoever the landlord uses. But there are various reasons why they might join or might not, but they can lobby one way or the other without joining. They can sit on the sidelines and talk to people without actually signing up. And if they're in the minority, they're signing up. Their voting rights don't give them too much, but the cost liability they could sign up to might be a disincentive.
Parliament, it looks as if Parliament thought there was something that they would do within that 14 days. But it seems like there isn't anything that they can do.
Look at their own arts.
Well, the 14 days is just to give them some time to mull over the question of do I join or not, for whatever reason they might want to.
Can I just ask what right of any value is given by section 78(4), which is the sending a copy of the memoirs or including a statement about inspection and copying it? Wouldn't an online search at Company's House reveal the memoirs?
It would. We were arguing, Mr Bates and I, in Ellen Court before the Court of Appeal about this when there was a failure to provide inspection on the relevant days of the week and whether that invalidated it, and the Court of Appeal found it didn't. Yes, there was a question as to why is this...
What's it all there for?
It's there...
Was this is it pulled over for some old day when actually going to Company's House was all rather palaver and this was thought to be simpler and cheaper?
Yeah, isn't this meant to be... Isn't this legislation meant to be capable of being dealt with by ordinary people without having legal...
It is. That is one aspect of it, yes. I suppose maybe in 2002... computers and access to the internet.
Yes, it may just not have been so easy to do an online search at Company's House.
Even now, not everybody has access to computers. Some people do like to deal with things in paper.
Yeah. So getting a copy is a real advantage compared to having to do whatever search you could have done in 2002.
Yes.
Yeah.
So we don't, if I'm following the discussion, we're not faced with a choice between the Court of Appeal's approach and the upper tribunal's approach. It may be they're both wrong.
Maybe, yes. But one thing in my submission the upper tribunal was clearly correct about is that this is not a point the landlord can take. So I've dealt with the fact that they don't have anything in the claim notice which enables the landlord to work out whether there's been a breach. Perhaps I could also just refer the court to the explanatory notes to the 2002 Act. If we go to page 1092, so here, just about towards the top, we have note 141.
1092.
So towards the top, paragraph 141, section 80 makes provision in respect of minimum requirements to be contained in the claim notice. These are designed to ensure that the company demonstrates that it qualifies to acquire the right to manage. So in my submission, that supports the construction that it's to do with qualification requirements, and that's apparent from the terms of what the claim notice contains. And then also, paragraph 149 at the bottom, which deals with section 84.2, the provision on counter notices that we've been discussing. Subsection 2 specifies that a counter notice may only either admit that the RTM company is entitled to acquire the right to manage or state that the company is not entitled to do so. To be effective, a counter notice to the latter effect must state the grounds on which the company is considered not to comply with the eligibility criteria set out in the Act. So that's what the focus of the claim notice is, demonstrating the eligibility or qualification criteria. And here is an indication as to the purpose of the counter notice. It's to deal with those eligibility criteria. It's not really concerned with procedural aspects of the scheme. And that is the key important thing in my submission to the landlord. Do the premises qualify? Do they have the numbers? Service of notices on third parties, why should that be of particular relevance to a landlord, other than to give them a reason to object to a scheme that they want to try and stop at all costs?
I see in paragraph 142 further up the page the example of non-entitlement that's given is, well, a property isn't eligible.
Yeah. Yes. Yes, and that's a clear eligibility requirement that the landlord could obviously take, and nobody, I think, would dispute.
I see. So the fact that the eligibility is something that's included in the particulars that have to be given doesn't automatically disqualify it for being a reason for serving a counter notice just because it's also included in the particulars, and therefore
Yeah, so if you
The
say in your particulars
inaccuracy.
that you qualify because it's a self-contained building, that's a valid claim notice that tells you the basis of your claim. But if that is factually wrong, that it's not a self-contained building, then of course the landlord can object to the counter notice, say you don't satisfy the qualifying criteria.
Yeah.
right, and it's not saved, as it were, by also being an inaccuracy in the particulars.
The claim notice itself would be saved, but the claim to require the right to manage wouldn't, because you can't just say, well, it's not self-contained, but that's an inaccuracy. That would, the whole statute wouldn't be workable in that situation. So we have an indication here in the explanatory notice of the purpose of the claim notice. We know the information it contains.
Just in relation to the notice of participation, do the regulations require any details to be given as to the qualifying criteria? And if you don't know, just don't spend time on it.
I can't recall. There's a prescribed form which, well, actually, we can perhaps just quickly look at the notice of invitation to participate in this case, just by way of example. One can see what it contains. At page 204 is the actual notice. I think there's no dispute that this is a compliant notice. It's just a case of one person wasn't served with the compliant notice. Quite a lot of the information is about how the scheme works if it kicks into effect. But I think I'm right in saying it doesn't, unlike a claim notice, it doesn't actually have to say this is the reason why the premises qualify.
Yep.
Whereas a claim notice would say it's a self-contained building or a self-contained part of a building, we have sufficient members, etc. So they do have different pieces of information addressed to different aspects of the scheme. Another way we can see from the statute that the claim notice's only purpose is to enable the recipient to ascertain the qualifying requirements is by looking at what rights under the statute the landlord and the right to manage company have in sections 82 and 83. So if we look at section 82, which you'll find on page 264, 82 gives a right to information, right to obtain information. That right is given to the RTM company. It has a right to obtain information identified in section 82(1)(b), information which the company reasonably requires for ascertaining the particulars required by or by virtue of section 80 to be included in a claim notice for claiming to acquire the right to manage the premises. The right to manage company has this right to obtain information. It can ask a landlord for information it needs to try and complete its claim notice. There is no right for a landlord to obtain information the other way. So there is no right under the statute for a landlord to say to the right to manage company, who did you serve with notice of invitation to participate, when did you serve them, how did you serve them? They want that information. Either the right to manage company has to volunteer it, or they're stuck with not knowing what the position is.
Sorry, have I got the wrong page here? This is section 82 you're looking at. And which page did you ask us?
Page 264.
It says at the top it's been superseded. This is this is what was in force at the time, but not now.
Yes. So this whole run of the statutory provision is what was in force at the time the claim notice was served in this case, to show the court what existed then. I'll have to double check what the amendments were to that. I'm pretty sure it hasn't changed this point I'm making. But
no, I've got it in front of me. It was the the 2024 Leasehold and Freehold Reform Act made some amendments, but it deleted some words in subsection 2b. After the words readily intelligible form, the sentence that now stops there.
Yes.
And
Fee.
it added subsections 4 and 5, which are to do with costs incurred by people in complying with the notice under the section.
Yes. So, notwithstanding the amendments, the point still remains that we have a right to information one way, not a right to information the other. So the landlord has no way under the statutory scheme of ascertaining compliance with Section 78. One thing the landlord does have...
Sorry, could you just follow through with that? So you show us that fact. So what do you say we infer from that?
That Parliament did not consider it to be relevant to the recipient of a claim notice to know whether or not Section 78 participation notice has been complied with. If that was a relevant consideration for the recipient of a claim notice, the scheme would give them a way of working out whether it's been complied with or not. And if it's not relevant, that supports the proposition that it's not something they can object to in a counter notice. This is not what they're given the claim notice for. They're given the claim notice to work out whether the qualifying criteria are satisfied. They can object if they're not. They're not given the opportunity to raise procedural hurdles to the acquisition of the right to manage. That's the argument that this is trying to support. If we look over the page at page 265, Section 83, there's a right of access. Now, this is a right for various parties. So, Section 83(1), where an RTM company has given a claim notice in relation to any premises, each of the persons specified in subsection 2 has a right of access to any part of the premises if that is reasonable in connection with any matter arising out of the claim to acquire the right to manage. Subsection 2 specifies the persons. So, these are persons authorised to act on behalf of the RTM company, and then the rest of them are the recipients of a claim notice or somebody authorised to act on their behalf. So, a landlord or other stakeholder who receives the claim notice, they have the statutory right of access. The reason why that might be relevant is they might wish to ascertain the internal floor area to work out whether the premises qualify. Is the commercial part of the floor area more than either 25% historically or 50% now? If so, that is an objection to right to manage based on a qualifying criteria that's not satisfied. So the landlord who gets the claim notice has that right. They can work out, do you satisfy the floor area requirement? But again, they don't have this right to work out whether you've served the participation notice on the tenants. Again, Parliament is giving lots of, well, I say lots, it is giving rights of access and information where it is necessary for this statute to work effectively. The notable omission is the inability of the landlord or other recipient of the claim notice to ascertain compliance with Section 78.
Can I take you back for a moment to Section 82?
Yes.
And subsection 3, a person to whom a notice is given must comply with it within a period of 28 days. What if he doesn't? What's the remedy?
There's an enforcement mechanism in Section 107, page 298.
Yes.
So
Now that is very interesting. Under 79(2), the claim notice may not be given unless every qualifying tenant has been notified at least 14 days in advance. So if that's not complied with, would the qualifying tenant be able to seek an appropriate order under Section 107? On the application of any person interested, make an order requiring a person who has failed to comply with a requirement imposed under this chapter to make good the default.
it is not something I've ever considered or has ever been raised in argument, but at first blush, it would appear that that would be an option available to a qualifying tenant.
Yeah. And so one doesn't...
Maybe over lunch, if I have time to think about that,
Yeah.
I might have some other comment. But at first sight, yes, that does seem potentially a way of dealing with it.
So really, if the statute provides its own remedial framework, then we don't really need to worry about synergy and concepts of voidability and so forth. We've got a remedy for the person interested in the default.
Yes.
Does that still go to the county court, or does that now go to the...
No, that's
tribunal?
been changed with the 2024 Act that Lord Reid referred to. It's now an application to the appropriate tribunal, which in England is usually the first tier tribunal. In Wales, it's the Leasehold Valuation Tribunal. So it seems to be consolidating everything with the tribunal rather than splitting issues under the Act between the tribunal and the county courts.
But suppose, I mean, again, you may want to think about this over the lunch break, but suppose then you have an equivalent to Miss O'Connor, but she does actually not want the thing to go ahead. She discovers that she hasn't been served. She goes off to the county court and asks them to make good the default. Can the county court put a halt on the continuation of the process by which the right to manage may be acquired?
Well, it's... Sorry. It doesn't seem to be something expressly stated within that provision. Seems to suggest
Making good the default would imply that you just have to serve the notice. It's a bit late in the day, and your opportunity for persuading all your fellow neighbours to, stick with the landlord is long since gone.
Yeah.
And
it's probably of less use in this situation. It doesn't mean it's not necessarily applicable, but it may be of less use to a tenant than it might be to a right to manage company which is trying to get information off a landlord and it can't even prepare its claim notice without the information. That's maybe where it more comes into...
But at first blush, it would apply to a qualifying tenant who wasn't served.
It would, but it may not be as effective for them in achieving much at the end.
No, because 1072 has some horrible time periods that have to expire, which would take you way beyond the 14-day cooling off period.
Also, once any tenant works out that they haven't been served, it's not too hard for them to get on top of it and apply to join if they want to. As happened in this case, it was a fairly simple matter for Miss O'Connor to join. The only reason she wasn't served with the notice or didn't join earlier was because everybody on our side was under the, now it appears, mistaken apprehension that an unregistered actual tenant was not a qualifying tenant, otherwise we wouldn't be here. As regards to...
I suppose you can say, can you, that even when you can see a sort of general purpose enforcement provision like this, it's not a necessary conclusion that every obligation imposed by statute has to have an effective means of enforcement. People often just do what they're told by statutes.
Yes. Yes, that's a fair point. I realise I'm fairly close to the end of my time. Perhaps I could just try and finish off this bit. So we do rely on some analogous reasoning by the Court of Appeal in another right to manage case dealing with non-compliance by a right to manage company with another aspect of the legislation. So perhaps I could just briefly show the court section 86.2 just to show the provision that the Court of Appeal were dealing with. So, sorry, this is page 270. This deals with notices of withdrawal. So, after serving a claim notice, an RTM company is entitled, for whatever reason, to withdraw that notice. the way it does it is to serve a notice of withdrawal, and section 86.2, a notice of withdrawal must be given to each person who is. There's 4 categories of people. The first 3 are the recipients of the claim notice, and the 4th category is the qualifying tenant of a flat contained in the premises. Now, in a case of Spire House, RTM and Eastern Pyramid, the Court of Appeal had to deal with a situation where an RTM company had served notice of withdrawal because it wanted to serve a new claim notice. It served the notice of withdrawal on anybody in the first 3 categories on one day. It didn't serve the qualifying tenants until the following day. The Court of Appeal considered that this was a breach of the legislation, that all had to be served on the same day. So there was a breach by serving the tenants the day after. And it had to consider what was the effect of that breach. Did it render the notice of withdrawal ineffective? If it did, that meant the RTM company couldn't serve a new claim notice the next day. Or was it effective, in which case the RTM company could rely on the next claim notice served whenever it was. Sorry, it may be the next day, I can't remember exactly what day. So with that lead into the case, if we go to Spire House, it starts at page 1039 in the bundle.
No, I'm sorry, could you give us a number again?
1039.
Thank you.
And within that, it's the particular passage is 1049. Oh, sorry, I may be out on my page numbering. No, it's 1046. Paragraph 49. Factor which is relevant is that there is no provision in the Act whereby the date on which the qualifying tenants are given the notice of withdrawal is to be communicated to the landlord. As the RTM company pointed out, had it not been for the tribunal proceedings in this case, which arose for other reasons, the landlord would not even know the date on which the qualifying tenants received the withdrawal notice. That supports the view that in the procedure, the timing of notice of withdrawal to the qualifying tenants is not meant to be important to the landlord. Indeed, going further, there is no reason why compliance with section 82.2d at all should be of concern to the landlord. So I agree with the first sentence of Upper Tribunal Cook's paragraph 63. If the landlord's argument was right, that makes it impossible for the landlord to know if the claim notice is withdrawn on the date they received the withdrawal notice. And I also agree with paragraph 64, which rejected the idea that Parliament's intention can have been that the landlord is entitled to rely on an alleged defect which it did not know about and did not affect it. Generally, one might expect landlords to argue in favour of certainty for landlords, whereas the landlord's argument in this case opportunistically relies on a construction designed to achieve the opposite. So that's a similar sort of approach to the one that I invite this court to adopt here. It would attribute to Parliament consistency of approach if one concludes in this case that the reason why there's an omission in the claim notice of information which enables the landlord to identify compliance or non-compliance with section 78 is because A, Parliament considered it is of no concern to the landlord whether or not anticipation notices have been served in compliance with section 78, and B, the landlord should not be able to rely on that point to oppose acquisition. So I say our approach here that we invite this court to adopt is consistent with the approach taken by the Court of Appeal there. Another point, if we consider the consequences of the respondent's construction, the right to manage company has to start again due to a failure to serve one tenant who has now joined the company, is content with the scheme herself. I'd like to refer the court to A1 Properties again on page 411. Here, Lord Briggs and Lord Sales were dealing with a point by Mr. Bates, paragraph 97 on page 411. A further point emphasised by Mr. Bates is that it is easy for an RTM company to start new proceedings by serving a new claim form. Therefore, he says, it should be inferred that Parliament intended that there should be strict compliance with the procedural requirements in the statutory regime. However, we do not consider that this is correct. 2 points may be made. So the first one, the purpose of the legislative scheme, as explained in the consultation paper, includes the objective... In fact, sorry, I think I read this out towards the start, so you have that already, that the procedural requirements are not included to create traps for the unwary. The next point I'd like to emphasise is paragraph 100. Secondly, the context in which the CLRA applies has to be taken into account. There is no guarantee that an RTM company will be in funds to be able to afford to make multiple applications. A RMT company might be formed by just 2 tenants or a small group of tenants with limited resources. And it continues to explain the problems with procedural requirements undermining to an unwarranted degree the ability of tenants and RTM companies to pursue the remedy in respect to problems regarding the management of their building, which Parliament intended should be available to them. As regards the ability of funds to deal with it, perhaps I could just refer to a point in the Law Commission report that considered this, page 1084, paragraph 8.15, has some information that the Law Commission obtained about costs of the process. So 1084, 8.15, many leaseholders who had experience of RTM said that the cumulative cost in a large block was very burdensome for the individual leaseholders initiating the claim. Michael Byrne gave the example of his RTM company spending about £1,000 sending out Section 78 notices when we already had 70% of the building as members. Bowcross West, Phase 5 Residents Association gave a cost of around £2,000 for 3 blocks and 97 private flats. A member of another RTM company said it had been £250 for a smaller block. So there are real implications in terms of costs for RTM companies if they have to start the process again due to procedural breaches. And again, it's another reason why we invite you to adopt our construction of the statute rather than that of the respondent.
Although that wasn't the case, I mean, there's no evidence that was the case here. I mean, the Court of Appeal sort of raised the question about why, in this case, the notice wasn't just served again.
So the reason why in this case was because the RTM company believed it didn't need to serve the notice. The First Tier Tribunal said that was correct. The First Tier Tribunal didn't say that's correct. It said you needed to, but the consequence is it doesn't invalidate it. So my client won. We won again in the upper tribunal. So if one is being supported by the tribunal, then why would they serve a new notice? It's only when we get to the Court of Appeal that then we are told the First Tier Tribunal has misunderstood the law, the upper tribunal has misunderstood the law, and with hindsight, yes, it would be very easy, but it's basically an exercise in hindsight that only once we have the Court of Appeal decision do we know that we should ultimately have done things differently back at the start of the process. One other point is it's actually not necessarily that simple as just to serve a new claim notice, because there's potentially an argument open to the landlord that the current notices of invitation to participate are not effective anymore and would need to be reserved. That's because a notice of invitation to participate, page 204, the example, has to specify the names of the members of the company in a schedule. The relevant tenant here, Ms O'Connor, is now a member of the company, so she should be specified in the schedule. So an argument may be put forward that, well, those are now defective, you need to reserve with her name on. Maybe the RTM company could say, well, we're dealing with the saving for particulars. Maybe there'll be another dispute as to whether they're valid. So it's not necessarily the case, without me wishing to give my learned friend arguments if we have to start again, it's not necessarily the case that you just serve a new claim notice and it's all hunky-dory. Potentially we end up in another round of litigation about whether the notices are effective anymore. The other point, sorry about Lord Snowden going back to that, the other point about whether it's simple, one thing in my submission the Court of Appeal lost sight of is this is not laying down a rule for this one set of facts. This is a rule that applies across the board, and not all cases will be quite as simple. So this court does have to envisage what happens in the 1,200 flat block. Is that simple? What are the ramifications across the board? Because this probably can't be restricted to the facts of this case. The only way in which perhaps it could would be by reference to the waiver argument as to whether Ms O'Connor has waived her rights. I'm conscious I've only got 6 minutes left, so I probably don't have much time to say much about that or anything else at this stage. But
Can I just ask you to look at section 85, which is at page 268. This is where the landlord isn't traceable.
Yes.
And it says this section applies where an RTM company wishing to acquire the right to manage premises complies with subsections 4 or 5 79. So they've got the right number of people signed up as members and would not have been precluded from giving a valid notice under that section with respect to the premises. Now, if they had not given a notice of participation to everybody they ought to have under section 78(2), do you say that would or would not preclude them from giving a valid notice such that they couldn't or could still use this mechanism? Because it's a bit like them being entitled under the wording that we've been looking at in 84(2)(b).
I don't think there's not been any real consideration of this in any of our arguments or the tribunal and courts below. But one way of reading this perhaps would be that that's focusing on the qualification requirements, the reference to the premises towards the end of section 85(1)(b).
So you're saying that, like the entitlement that's been referred to in 84(2)(b), they're really only precluded from giving valid notice if it's a provision, the provision that they've failed to comply with is not one that's of concern to the landlord, is that how you would put it?
Yeah.
It's a slightly curious provision because one might have thought that a failure to comply with subsections 4 or 5 of section 79 might have precluded them from giving a valid notice, but clearly it doesn't. Because it's not would otherwise have been precluded. So B must be focusing on something more specific.
Yes. Perhaps an unusual provision that requires some thought. I'm afraid I haven't given it a huge amount of thought until Lady Rose's question.
It's just, it seems to be the reverse of the entitlement.
Yeah.
Are they precluded because they're not entitled to serve a notice?
Yeah.
Similar sort of wording.
Yes, because, for example, it's the wrong kind of premises or the wrong kind of company.
Yeah. I'd support that analysis. I think I'm down to 3 minutes because I'm conscious my old friend only has 20 minutes to get going before lunch. Unless there's any specific questions, I probably can't really start any more points.
No, we'll give you a couple more minutes for your reply time.
Yeah, thank you.
I can surrender 5 if it makes more sense, because it's fairer that my learned friend says anything and I respond rather than he picks it up and reply. So I can surrender 5.
Well, again, what can one do in 5?
So, well, if you're struggling to find something worthwhile to tell us at the moment,
probably a waste of time for me to try and fit something in.
Then perhaps we should hear from Mr. Bates. Thank you very much.
Thank you. My lord, my lady, with my 20 minutes or so remaining to me before lunch, I'm going to put my notes to one side for a minute, and I actually want to just focus on the questions the court was putting to my learned friend. Give the answer to those. For good or for ill, they marinate over lunch, and then I'll pick up the substantive case I want to advance later on. The starting point has been touched on by Lady Rose and then by Lord Reid. In our respectful submission, the concept of nullity isn't really going to help us here, because every time it's been put in the written materials and by my learned friend in his submissions, he's using it in the shorthand way that this court talked about in A1, where we know what he means, but nullity doesn't really take us very far. So if we just have a quick look at A1 properties.
Before doing that,
My lord.
Didn't the Court of Appeal use it in that sense? Nullity, invalid, has no effect. Written water.
Well, I'll give you two answers to that, my lord. The first is, I don't think they did. I think they were doing the kind of shorthand summary that works in most cases.
For what? What did nullity mean to the Court of Appeal then?
Well, it seems to me what they meant was it wasn't sufficient as a notice to confer the right to manage. It was sufficient as a notice to start the statutory process. But if my learned friend is right...
So not sufficient as a notice to... What, sorry?
To transfer the management. But it is a sufficient notice to put me and my client at the election of do we serve a counter notice or not, and then the tribunal to rule upon it. And that's the point this court was making in A1 at paragraph 94.
So the words may not be given may not be given.
So can I just take to 94? Yeah. Because in my submission, this whole language of nullity is a red herring. I agree with my Lord's question. We're going to have to look at what the wording of the actual act is. But nullity doesn't help us because, as is recorded at page 410 of the authorities, paragraph 94 of the report.
Just bringing back to section 79, subsection 2, the claim notice may not be given means the claim notice may be given, but is not sufficient to transfer management. Is that right?
So it means that, if I can just do 94 and then I'll answer my Lord's question. Yes. I'm not ducking the question, but 94 gives the answer, I suppose, in a better way than I can. You see at 94, the parties debated the issue in terms of whether it was valid or invalid. It was convenient shorthand, but Mr. Rainey, King's Counsel for the intervener, pointed out that it clearly was a valid notice. It was issued and given to the management company, and it was valid in the sense that it was what it purported to be. The question was whether it was a sufficient foundation to transfer the management. That's the same issue here.
Well, the next bit is important, so that in the event of a dispute, the tribunal would be closed with authority.
Quite, my lady, yes. So we haven't looked at the claim notice here. I don't want to take you to it because time is not our friend. But it clearly is what it purports to be. It's not a notice to quit. It's not that someone served a break notice. It's not a blank piece of paper. The right form has been downloaded from the internet and the details have been included. It is sufficient to mean that when my client receives it, they have to do one of the three things that a recipient of a claim notice does. Either serve a counter notice denying the right, serve a counter notice admitting the right, or do nothing. If they admit or they do nothing, we then have the deemed provisions that my lady looked at earlier. The Act has its own mechanism for when the right will pass over. And if they dispute, it's the giving of a counter notice which says, I dispute your entitlement, triggers the FTT's jurisdiction, section 84.3. The right to apply to the FTT arises only when you get a counter notice that says, I dispute your right. So, finally, to answer my Lord's question, it was an effective claim notice to mean that I, in receipt of it, had to look at section 84 and say, well, which of these three options do I want to now engage with? It wasn't so obviously bad on its face that I could ignore it. I chose to do the response which says, I deny your right, which means in turn, picking up 91 and my lady's point she took us to, it was a sufficiently valid notice to give the tribunal jurisdiction to decide the question of entitlement. Now, I don't think the Court of Appeal was saying anything different. I think they just slipped into the shorthand that had been the debate in A1 before Mr. Rainey cut through it all. But if they were saying that, sorry, my lady, but if they were saying that they're wrong because you told us what the answer is in A1. Sorry, my lady.
So if you do nothing or admit it, then is it a sufficient claim notice to trigger the deemed acceptance and the transfer in section 90?
That is a very much more difficult question, I think, than has perhaps been appreciated. On the one hand, the answer is yes, because as my lady put to my learned friend, you've got the deemed provision in section 90 sub 3, if you don't respond, you're deemed to have accepted, and so one might say, Parliament has therefore said, well, you made your bed, you lie in it. As against that, there's another provision which you haven't been taken to yet. It's in 247, section 71, introducing the right to manage. So the first provision of this chapter. This chapter makes provision for the acquisition and exercise of rights in relation to the management of premises to which this chapter applies by a company which, in accordance with this chapter, may acquire and exercise those rights. So, on the other hand, it does look like this is a self-contained scheme. If you serve a notice on something which does not qualify, it's a caravan park, let's say. That doesn't look to me like premises to which the Act applies. And so by section 71.1, we don't need to worry about the rest of it. The question, if that's right, the question is where would you have that fight? You could serve your claim notice on my caravan park. I serve a counter notice saying this is not premises to which the Act applies. The FTT, it seems to me, could answer that question because it would be a counter notice in the right form, not a notice to quit, not a break clause, whatever. And the FTT says, well, these aren't premises to which the Act applies, full stop. Or conceivably, it might be what this court alighted on in A1 at paragraphs 87 and 88. There might be rights to go to the High Court and seek declaratory relief. Or, if someone had completely missed all this and the FTT had made a decision, you might need to go to the High Court and get it quashed.
So the counter notice in your example would be one alleging that by reason of the provisions about premises to which a chapter applies in section 72, the RTM company was not entitled to acquire a right to manage the caravan park.
Yes, my lord. Yes.
Yes, but what we're looking at here is suppose the landlord doesn't. Suppose there's a claim notice put forward for a caravan park. The landlord doesn't do anything. I think you're saying there's a limit to how far removed from this chapter the claim notice has to be to stop the deeming provisions from operating. There must be some. Is that what you're saying? That yes.
Section 71 must be doing something.
Right.
In my submission, what it's doing is it's telling us if you don't fall within this chapter, you can't have the rights in this chapter.
Is it, or is it just by way of introduction? It's just telling you what this chapter does.
Well then, but you also have section 2 telling you how the rights are to be acquired and exercised. So it's not merely what this chapter does. It's telling you that this chapter is going to regulate the pre-claim process, the claim process, the post-claim process, and the actual management the RTM company does. We haven't looked at it yet, but
I mean, suppose that, I think you're saying that the concept of premises to which this chapter applies lies somehow outside the deeming process. But suppose it was a borderline case on some square footage ground or something of that kind, and the RTM company sends in its claim notice saying, we qualify, and the landlord can either say, no, you don't because you've got the square footage wrong, or yes, you do, or do nothing.
yes.
And one would think that the deeming provisions would kick in that sort of situation.
I think I would agree in those circumstances. And you could think of similar ones where a landlord might have an argument around the edges, and frankly, we aren't going to know if it's right or not until we get in front of a tribunal, and it depends on whose surveyor is accepted or whatever it may
But
be.
we don't want to get in front of the tribunal because we're happy to.
Exactly.
Yeah.
In those circumstances, the Act allows a landlord not to serve a counter notice, and if it's premises to which the Act applies, you go through.
Well, that deals with a borderline case. But how about a case which is slightly more apparent?
Well,
Where do you draw the line?
In that situation, in my submission, it plays out looking at the way that this court did it in A1 properties. You can't go to the FTT unless the landlord has served you a claim notice and you serve a negative counter notice. So, if it's a case which is obviously defective, my holiday park, the landlord serves his counter notice. Looking at how this court dealt with nullity in A1, the tribunal would still have power to say, these aren't premises to which the Act applies, claim fails. But this court gave us two other options in A1. It's paragraphs 87 and 88. One is that someone else could find a way of taking the point in the FTT, which is what happened in A1. One of the landlords took the point. The landlord who wasn't served found out about the case, applied to be joined. So he took the point even though he hadn't been served. And if that's what happens, says this court, that's still fine, because the tribunal then makes the substantive decision. The other option, said this court in paragraph 88, is you go to the High Court, either for a private law declaration that this is not a right to manage company because it's a caravan park and it doesn't apply, or if there's been a tribunal decision, you go for judicial review and you quash the tribunal decision because it wasn't premises to which the Act applies. The answer, said this court, in both of those cases, is that because both of those remedies are discretionary, a discretionary declaration, judicial review remedy is always discretionary on usual principles, the landlord who sits on his hands for very long periods of time may find he doesn't get a remedy. But that's how we deal with the counsels of despair that my learned friend was putting to you. Landlords who sit with these points in their back pockets, saving it for a rainy day, are going to have to persuade a High Court judge why they should have relief when they've sat on it for years. So I think that's the answer to that. Before breaking for lunch as well, I wondered if I could ask you to focus on section 79.1, because we've gone to section 79.2 a lot. But 79.2 is parasitic on 79.1. It's 79.1 that's the important one, because that tells us how you start the right to manage claim. You give notice of the claim, and then what it also does is it freezes the date at which we are to assess eligibility, i.e. the relevant date, which is the date of the giving of the claim notice, sorry. 79.2 only kicks in, and it kicks in as a prohibition on giving that notice, if there was someone who had to be given a notice inviting participation, and that wasn't done at least 14 days before. So you go back to, so what you do, so imagine the situation. I am a landlord and I'm served with a claim notice. In order to know whether or not I can take a section 79.2 point, I start with the date on which I received the claim notice, because that's the relevant date. And I ask myself, was there anyone who was required to be given a notice of invitation to participate on that relevant date? I go back to section 78.1. If they're all members of the company, there was no one on the relevant date who was required to be given a notice inviting participation. The 79.2 works only once you've first done section 79.1. So can I give you 4 worked examples to try and show this through? Imagine that I'm a landlord and I've received a claim notice. There's 10 leaseholders in the block, 5 of them are in the company, and 5 of them weren't given NIPs at all. My case is that's fatal, because section 79.2 says the claim notice cannot be given until all of the people entitled to receive the NIP have been given one at least 14 days before, and we know that 5 of them didn't have anything at all. Therefore, the notice cannot be given. If it cannot be given, it cannot be a notice which transfers the right to manage. It's a notice which lets me go to the tribunal to have this argument, but it can't transfer the right.
So it forms the basis of your counter notice?
Yes.
That they were not entitled to serve the claim notice because they had not complied with section 78.
Absolutely.
But it does transfer the right if there's a deeming provision, if you don't object. Or
if I don't object, then the deeming provisions may start to kick in. But assume I've objected.
Well, it is effective then to transfer the right.
Well, because Parliament has decided that because I don't, in a case where my argument is not about its premises to which the Act applies, section 71.1, Parliament has created a deeming provision, and my landlord client in that situation just has to live with the consequences of that if he chooses not to take the point. What about the second scenario, which is, again, my block of 10, 5 of them are in the company, and 5 of them aren't at the beginning. The 5 that aren't in the company don't get NIPs, but they nonetheless join the company before service of the claim form. They just find out about it from talking to their friends, and they join before the claim form is served. That wouldn't be a Section 79.2 problem, because on the relevant date, there was no one who was required to be given an NIP, because they were all members of the company. And you don't have to give an NIP to someone who isn't a member of the company.
Sorry, could you go back?
Sorry, yes, Mike.
Sorry, you say that there are 10 tenants in the block, 5 in the company, 5 not in the company.
5 not in, yeah. And the 5 who are not in do not get given any NIPs.
Right.
But they nonetheless find out about the company, and they join it, as is their absolute right. So that by the time of the giving of the claim notice, all 10 leaseholders are members of the company. In that situation, Section 79.2 doesn't bite, because on the relevant date, there was no one who needed to be given an NIP.
Well, it depends, doesn't it, about... They were... Sorry, at what point they join...
They join before service of the claim notice in this example.
But within the 14-day period.
But the 14 days is irrelevant in this argument.
That's what I'm just trying to get to.
14 days doesn't matter. So I have to decide, on the relevant date, am I taking a point about whether this company qualifies or not? If I want to take the Section 79.2 point, I have to say that on the relevant date, there was someone who had to be given an NIP who'd not been given it or not been given it 14 days beforehand. If they are all members of the company, even if they'd all only joined yesterday, there's no one who has to be given an NIP. It's the same analysis, very quickly, it's the same analysis if they are outside the company, they're given their NIPs, they all join, but the claim notice is served earlier than the 14-day period. Because on the relevant date, there is no one who needed to be given an NIP, so there is no 14-day period to elapse. 79.2 works by the landlord having to decide on the relevant date, is there someone who should have been given an NIP who has not been so given? If they are all members of the company, by whatever route, then they don't have to be given an NIP. The critical thing to appreciate here is that there is someone who wasn't a member of the company on the relevant date and who hadn't been given the notice of it.
And what remedy does that person have?
Well, that, I suspect, my lord, is the question to come to after the short adjournment.
So there's someone who is not a member and was not given an NIP and does not become a member
before
by the relevant date.
Exactly, yes. And it must be the relevant date because, and I will stop, but Section 84.2, the counter notice is a notice containing a statement either admitting that the RTM company was on the relevant date, so entitled, or alleging that by virtue of a provision, the company was not on that date, so entitled.
Sorry, what are you looking at?
Sorry, I'm looking at 84.2, my lady, 266. It's why I say the landlord has to make his decision about what argument he's got available to him on the relevant date, which is the date of the giving of the claim notice. If at the date of giving of the claim notice, they are all members, whether by hook or by crook, 79.2 doesn't arise. It only arises where there's someone who isn't a member on the relevant date.
Where it says specified provision, that means specified in the counter notice.
Yeah, pleaded.
Yeah.
Yes. So we'll have a look at a counter notice later. There's a dotted line text. You fill it in, identifying what provision of the Act you say wasn't satisfied. Yeah. So what you can't do, it's clear from the wording, I'm just clear from all the extra legal materials. What you can't do is say, you will be terrible managers. You have no relevant skills. Your agent is a notorious crook. that's not a reason you can put forward. You've got to come up with a reason why something in the Act prevents the transfer of management.
Yeah.
And that's the question we'll come on to after lunch, if I may.
Yes, very well. If that's a convenient point, we'll resume at 2 o'clock.